I just spent 2 years as the executor of my uncle's estate. I am not going to put my kids through that. No way. Hi, Jeff Mersace, the Plain English Attorney, and welcome to the video. Today we're going to talk about, is a revocable living trust right for you? Now, this may sound like it's a very simple question, and unfortunately, a lot of attorneys that do estate planning or say they do estate planning as a bit of a side gig to what they usually do in the main part of their practice, oh, your estate is above this amount or below this amount, you need a trust or you don't, just depending on what your assets are. No, that's not the way to look at it. And I'm going to talk a little bit more about that later and how to really take a look at things from your perspective on what's important to you. But avoiding probate is really determining whether a revocable trust is right for you. If that's a main goal, well, then getting a revocable trust makes sense. So what's the alternative is, all right, you can simply do nothing. And this happens all the time. In fact, about 70% of the time are the statistics that hold up over a few decades at least, that 70% of the people do absolutely nothing. So do they have an estate plan? Yeah, they do. It's the one the government gave you. All right. Do you really want the government to say, here's where your estate goes because we're telling you these are the people who are most important to you and when they should get it and who should be in charge of your estate? No, most people don't want that. What they do want is to determine, here's the people that I want to be in charge of handling things if I pass on, and also if I become incapacitated. And if I pass on, here's where I want my assets to go and when I want it to go to them. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. If you imagine, all right, I'm not going to do anything. I've got a spouse and 2 kids, and all right, I'm not going to do any plan because I want my spouse to get a third and the kids to split the other 2/3, and I want them to get it at age 18. Most of my clients would start going, what? No, that's not what people generally want. If you're married, most of the time they want the spouse to be the first in line to inherit everything. Maybe there are a few things that go to specific people. And then it goes down to the kids in large part or partially. That's what most people want. They don't want this split. But look, if you want to leave it up to the government to determine who your beneficiaries are and when they get stuff, you don't have to do anything. Most of my clients actually want to do something. The second piece of that, quote, government interference is if you use a last will and testament, that means that the court has to be involved in transferring title for your assets. And that's really all probate is. It's a big, massive retitling process that has a ton of paperwork that most people consider unnecessary. So we're going to talk a little bit about that. So when you're trying to determine whether or not a revocable living trust is something that is right for you, what you're really doing is seeing, do I want to avoid that government court process of transferring my assets to the people I want it to go to? Now, we're going to dispel one myth right away. Okay, I have a last will and testament. My estate avoids probate. No, absolutely not. A will is actually your ticket to probate, and it says, here's where I want the court I want to put this person in charge. Here's where I want my assets to go. Court, go ahead and make it happen. That's not what most people want, but that's what a will does. It takes it through that court process. Now, some people consider probate court, well, it's no big deal. I don't care if my estate has to go through this process when I pass on. The heirs are lucky to get what they're going to get. They can wait. They can deal with whatever that cost is for it. I don't care. That's fine. Look, that's fine. There's nothing saying that you have to avoid probate. On the other hand, there are a lot of attorneys that make it sound like, oh yeah, no big deal. Probate is simple. It's no big deal. We handle probate all the time. And what it ends up getting is a huge amount of money in fees to the law firm that's handling the probate process. Now, look, I've dealt with probates. My firm doesn't actually do that work currently. We prefer to have another attorney that enjoys doing that type of work. We like to focus on avoiding probate. I have no issue with attorneys that end up charging to do the work that they have to do, and it is a significant amount of paperwork and gathering documentation and putting it together and submitting it to the court and doing that for the estate and for the clients. I've got no problem with them getting paid to do that. What I do have a problem with is attorneys that say, oh yeah, we'll do your estate planning for you. We'll do a last will and testament. Oh, probate's not a big deal. No, they're lying. So again, no problem with attorneys getting paid to actually do the work, but trying to entice people to have their estate go into probate so that they can make more money down the road, that is something that most people have a problem with. So what exactly are the costs around probate court? Generally speaking, it's about 4 to 10%. Now, these are the numbers that I've looked at. There's actually an AARP study out there from a long time ago saying it was about 8 to 10%. Again, at least in North Carolina and most states, you look at it, it's that range of between 4 and 10%. And in fact, it's extremely common for attorneys and law firms to say, well, tell you what, make us the executor and we'll do it for a 5% personal representative fee. So they get 5% of the estate. Now, for a lot of my clients on the planning end, they look at, they go, 5% of everything I own is going to go to you? I don't want that. On the other hand, you get to the point where the beneficiaries are going, well, okay, we're going to get 95% of everything, but we don't have to do anything. That's not a bad deal. Well, look, if you've got $1 million, do you really want $50,000 to go to the attorneys to handle paperwork if it can be avoided using a revocable living trust? Most of my clients are saying, yeah, we want to avoid that court process. So that's when you're talking about probate and the downsides, that's the big one, is the cost. Now we've got 3 more. The second big downside of probate is it takes time. So it's probably, I give the range of between 6 months to 1.5 years. Now 6 months is extremely optimistic. 1.5 years, okay, I'm not going to say that's about right. That's a little bit on the end, the further end. At least in North Carolina, when you're handling probate, 11 months tends to be where more of these estates fall, because if you don't get it in before the end of the year, now suddenly there has to be an annual accounting thrown on top of that. And so people, the attorneys will pretty much push as hard as they can in order to get it in under that year mark so that it's a final inventory and you don't have to do an annual accounting and then do a final inventory and accounting. So, all right, 11 months. That's a long time for a lot of my clients when they're thinking about, wait a minute, my beneficiaries need that money. We don't want this hanging over their head that this is still going on. And look, there are some estates that can go 3-4 years or more. I mean, there are some estates when, especially if things get contested, that it could take a decade or more. So it takes a long time. And that can come around to that third big downside. It's more open to being contested. Okay, what exactly are we talking about with an estate being contested? All right, if an estate is being contested, somebody doesn't like what they're getting. So sometimes I have clients where, all right, I've got 3 kids. We don't necessarily want it equal, but here's why. And they've got a good explanation. One client was, okay, we've got 3 kids. Well, actually, in this example, they had 2 kids. One of them got all the scholarships, worked really hard, and they hardly had to pay anything towards their college education because they got all these scholarships and they worked. The other child, they didn't get all the scholarships. They went to a private school, and it cost a lot of money, and they're like, yeah, we're going to pay for that education. But then when it came time for the estate, they wanted to make it a 60-40 split, and here's why. Now, if that 40% child said, this isn't right, my parents didn't know what they were doing, I don't think they were in their right minds, I hate my brother now, and I'm going to go to an attorney, and I'm going to get this fixed so that I get my full half. Right? If it's in the probate court process versus if you have a revocable living trust, that is two entirely different processes. All it takes to contest an estate that is in that probate court process is filing certain paperwork to object to the way things are handled. And now there's a hearing before the court. And a lot of the time, the attorneys are getting paid out of the estate, whether they win or not. It has to be, in fact, it pretty much has to be that there was nothing, it was frivolous, in order for the estate to not have to pay the attorney for bringing the contest. So, well, okay, if that's what happens in probate, what happens with the revocable living trust? Well, now suddenly it's not in that probate court process that is designed to very easily accept challenges and make sure that the professionals get paid. It's suing the revocable living trust. So you actually have to file a lawsuit. And at least in North Carolina and a lot of other states, it's very difficult to have that trust say, well, yes, it was so egregious and my client was so correct that the trust should be paying the legal fees of the person bringing the contest. It's very, very difficult. They have to file the lawsuit. So if you're an attorney handling a contest through probate court and you know you're very, very likely to get paid, well, okay, we can, quote, take this on spec. All right, we're going to get paid. If it's, okay, we're going to have to fight and sue this revocable living trust and we're not likely to get paid out of the trust, then they go to the person wanting to bring the lawsuit. Oh, well, then we need $15,000 up front as the retainer. We're going to start with, whoa, no, you get paid when I get paid. Oh, no, that's not the way the attorneys are going to handle it. And what I found in my experience, people who want something that they're not entitled to rarely want to put up their own money in order to get it. So that's what really pushes off these contests and makes it a lot more likely that a revocable living trust is going to defend against a contest. And now we're getting to the fourth big downside, and it's privacy. Look, a probate estate is not private. It's a court proceeding. It's a government proceeding. All of that paperwork is open to the public and can be inspected. And in fact, I've even seen, it's been years, I've seen these marketing people go through the probate court files and checking and writing down the names and addresses of beneficiaries who look like they're going to get a bunch of money at some point in the near future. In fact, all right, this is a story going back a long ways. Actually, I got two stories for this one. I had a client call me many years ago, and he called me on a Friday afternoon. And the way I remember it was a Friday afternoon. He said, Jeff, I have a Friday afternoon question for you, which was kind of his way of saying, I'm only going to ask it if you promise not to bill me. And I'm like, all right, fine. What's the question? My dad died in Michigan about 4 months ago. Does that have anything to do with the fact that I'm getting all of these brochures from Mercedes and BMW? Yeah. They went through the probate files, you got put on a marketing list, and now they want to be first in line to help you spend your inheritance. Isn't that nice of them? Look, that information ends up out there. Now, even more concerning, and I do have clients that look at this as an issue, if you've got a younger, particularly a younger female beneficiary who's going to be receiving a lot of money, they are worried about scam artists and these romance bros who are going to try to take advantage of someone who's inheriting a bunch of money. So having that financial information out there is a big detriment. The other story is there's actually a financial advisor that I had met at a conference, and she was talking about how she did seminars and what she would typically do when she went into a particular area. She'd go to the probate court the day before, get a pretty recent probate file and get copies of everything. And then when she went and started doing her workshop, she'd open up the probate file and go, oh, look, they had $352,000 in this in this checking account. That's a lot of money to just have in a checking account. Oh, and look, we've got this investment account that's got this much money in it. Wow, that's a lot of money, isn't it? Oh, look, we've got 3 kids, but it's a 40-40-20 split. Bet there's a good story there. And she's reading off all this stuff and looking at the stunned look in the audience. But there was a guy in the back row, and he was turning red with anger. And he stood up and he's like, I can't believe you're doing this. You're invading her privacy. I knew her. She was a good woman. You have no right to do this. And she said, no, that's exactly my point. I have every right to do this because it's part of the public record. Now, if you don't want your financial information and family information disclosed to the public, then you really should consider using a revocable living trust. So these are the downsides of probate that people want to look at and start doing an analysis. Okay, do I want these downsides, or do I really not care? And sometimes it's you don't care, and that's fine. Go ahead and use a will. But by and large, if you want to avoid the government oversight and the public disclosure of information, you are talking about a revocable living trust. All right, so let's talk a little bit about this analysis and cost benefit. There is no hard and fast number. There just isn't. And there are a lot of attorneys who try to make it sound like, yeah, it's no big deal. If you have $3 million or more, then you need a revocable trust. Oh, you've got less than $3 million? No, just go ahead and do a will. Look, that is lazy. That's not doing anything to discuss what your particular goals are. And if avoiding probate is a big goal, then that's something that you should be talking about is the revocable living trust. I remember this one client very clearly, and it was more than 15 years ago. He had $6 million back then. So what would we be looking at? Somewhere around 15, 16 million in today's dollars or more. And what he said was, look, 4 to 10%, that's the cost of doing business. I don't think it's that big of a deal. 6 months to a year and a half. Yeah, who cares? They're lucky they're getting anything at all. Disclosure of information. Well, everything's on the internet these days and open to contest. My kids aren't going to contest. Look, that's fine. You have all that money. Go ahead and do a will. And in fact, he said, look, is probate really that bad? He was almost like he wanted to argue with me. I'm like, well, yeah, it can be. Let's make my younger son the executor. I think it would be a good learning experience for him. All right, fine. That fit their goals, even with the high dollar value in their estate. On the other hand, I've had clients with maybe as little as $200,000 in assets, and that kind of includes the house. And I just spent 2 years as the executor of my uncle's estate. I am not going to put my kids through that. No way. All right, so that's when we look at the revocable living trust as a way to avoid probate. So, all right, what does this revocable living trust do? You're setting up this trust. You are the trustor setting it up. You are the trustee. You're in charge of it. You're the first level beneficiary. And now all of the stuff that you normally expect to find in a will after you pass on, okay, this goes to this person, this goes to, and here's the age limits that we've set in place. All that stuff is in the trust, which means it's outside of probate. So it's a lot easier to settle. You don't have all of the inventories in the court requesting and requiring copies of canceled checks and exact, written out appraisals of and values of things on the date of death, and it's just a whole lot of formal paperwork. All that stuff is avoided for what's in the trust. You can be a lot more informal. As a trustee, you still need to have the records, but you don't have to be so rigid and formal about it. So that greatly reduces the costs. It greatly reduces the distribution time because it can be wrapped up a lot more quickly. It's harder to contest, as we talked about. And anything that's in the trust does not have to be disclosed to the public. So at the end of the day, if you're doing this right, your revocable trust is going to have an accompanying pour-over will. And that just means it's a last will and testament. You name your executor, but the only beneficiary is the trust. So no one knows who the actual beneficiaries are. So that's why a lot of my clients look at the revocable trust and they go, yeah, I do not need the court and the government, and I certainly don't need the marketing people and the general public to know what's going on in my estate. I want to keep it out of there. So this is really the analysis. Do you want the revocable living trust? And take the time to set it up properly. It is going to be a little more expensive than just doing a will, having all the other documents put in place, and then take the time to make sure your assets line up with the trust. Is that what you want to do? Versus, okay, it's going to be a lot less expensive to do the will, but I just know it's going to have to go through probate with the will, but I'm okay with it. That's a question that's really up to you. And like I said, there is no hard and fast number. And in fact, a lot of attorneys do this, and it's shameful. Oh, you have less than $13 million. You don't need a trust. Right now in 2023, that $13 million is really $12.96 million. That's federal estate taxes. Estate taxes have absolutely nothing to do with how your estate is going to be processed. It's a totally separate question. It's like saying, oh, you don't need to change the oil in your car because your gas tank is full. That doesn't make any sense. That's also the way it doesn't make any sense when attorneys tell you, oh, you've got below this dollar amount, you don't need a trust. No. That's just being lazy. You really need to take a much longer examination and see what works right for you. So that's really getting to the heart of the question, is making this cost-benefit analysis, discussing with your estate planning attorney who knows what they're doing, what are the different ways to set up the estate. And really it comes down to will or revocable living trust is the best two ways to do it. And that solid question is, do you mind with all those downsides, whether it's in court, or do you want to keep it out of that process? If you want some more information that's online and free, check out our free course at freetrustcourse.com. Just get access to all that information, and now you can look and see what's going to be best for you. So I hope you found that information useful. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.